Good morning, friends. As usual, the judgment which I am going to share with you, though pertaining to civil suit, but do not ignore the judgment because this is not only applicable to civil suit, it is also applicable to all proceedings wherever the complainant or accused died. So, question of abatement arises in criminal cases, but sometimes it works. Suppose some compensation is ordered and pending after judgment and appeal is pending. If the appellant died, then the question arises about substitution of legal heirs to so many area has to be understood. Domestic violence act cases, maintenance cases, and also family court cases, suits and OPs, where there is possibility of death of the one of the respondent. So, lot more you have to understand. For that, I just refer the judgment. AR 2025 Supreme Court 1201. AR 2025 Supreme Court 1201. This is Om Prakash Gupta alias Lalluva versus Satish Chandra Om Prakash Gupta alias Lalluva alias and versus Rupar. Suits were pending and suits decreed appeal. Thereafter, second appeal was prepared and pending second appeals, both second appeals. Deceased died, but unfortunately, it is a lack on the part of the deliberate, or I do not know whether deliberate, intentional, or inadvertent. The council simply filed an application to substitute sons of the deceased without even informing the date of death of the deceased. That's why there are three ratios given in the Supreme Court judgment regarding Order 22, Rule 3, substitution of party. Then question arises Order 22, Rule 9, abatement. If suppose application to set aside to substitute was not filed within stipulated time, 142 of the Limitation Act and Section 10A, Order 22, Rule 10A, which caused duty on the councils or party to inform the court about the death of the party, furnishing the date of death and other things. Here something had happened, but however, initially the High Court has set allowed the substitute application, but unfortunately did not notice that setting aside abatement was not filed. Therefore, subsequently recalled the order passed to substitute and declared abatement of the second appeal. So, the Supreme Court has stated that though the appeal was filed against the order passed by the High Court in original case, since they have not challenged about the order of passing abatement, the Supreme Court has given ratio stating the Supreme Court has got power to set aside the order which is not legally passing. Therefore, they have set aside all the orders and allowed abatement, permitted the parties to bring LR on record, and finally issued direction to complete the suits by 6 months. This is what I would like to concentrate on these issues also, but you cannot ignore this area of CPCs if you because you cannot exclusive practice in criminal side because before criminal court also you have to face 138 negotiable instrument act cases and also domestic violence cases. Therefore, kindly concentrate and slowly read, go through CPC, purchase CPC. If not having, go through this Order 22 rule. You slowly learn one by one about all these things which are relevant to even for criminal cases, family court cases, etc. etc. Best wishes. I have a lot to discuss. Not now. I'm not well.